Appeal against Maxwell.
Yes, Mr. O'Connor.
My Lord, good morning. 3 points which I hope will be disciplined. My Lord, we were at page 70 in our case, and we broke off looking...
70 of what, were we?
70 of our case, the appellant's
Of your case, sorry, yes.
At the bottom. And we were, I was beginning to make submissions about the threat to the fairness of the proposed retrial, which is, of course, quite the other limb of abuse of process. And the Court of Appeal dealt with this in one sentence at paragraph 65 of their judgment in the following terms. In our view...
Sorry, paragraph...
65.
60. Yeah.
In our view, if there is to be a retrial, the trial judge can ensure that the prosecution calls no challenged evidence, the reliability of which may be undermined by what the North Yorkshire Police and the CCRC have now uncovered. We submit that the court misdirected itself there significantly by confining its attention to the undermining of evidence to be called by the prosecution at the retrial. The concern is far more profound, and in a nutshell, it is about evidence that nobody will ever recover and which has been suppressed, particularly by the disclosure officer in the course of this investigation. May I explain what I mean? Give examples. In our case, I'm looking at just now over the page 71, paragraph 5.38. The senior officer in charge of disclosure was Detective Inspector Butler. It is significant, Lord, that he refused to cooperate with the CCRC North Yorkshire Police investigation. We make various paragraph references there to the CCRC statement of reasons. May I explain what they mean? First of all, can I take you in the statement of reasons to paragraph 203. Two, 203 of the...
This is volume 2.
It's volume 2. And one sees there, this is the lead-up to the deception of the Court of Appeal. 203 is the latest of the queries outstanding from the appellant's solicitors, and one sees 204, the CPS referred these inquiries to Detective Inspector Butler, who, by the way, there is not just the disclosure officer, but Deputy Senior Investigating Officer. And D.I. Butler informed the CPS that the information that Chapman was to receive £100,000 is totally without foundation and indicates that there are policy reasons why further information should not be given in answer to these inquiries. We should not therefore provide any information which has been requested, not prudent even to inform Mansell's representatives that Chapman remains in custody. And 205, there is a statement actually made, bottom half of paragraph 205, by Mr. Butler to North Yorkshire Police. So his non-cooperation must mean he wasn't prepared to be interviewed by them. But his version to the CCRC was that he was unaware of any payments which had been made to Mr. Chapman, including even those disclosed at trial on the minimal and deceptive basis.
I'm lost, Mr. McConnell. I mean, what sort of evidence are you talking about here being suppressed? If it's merely evidence that goes, so to speak, to add a few more elements to the extent to which the police were doing Chapman's bidding in the way of giving him this, that, and the other. I mean, so what?
I agree, so what? That's not the point, my lord. We are looking ahead at a proposed retrial.
Yes.
And we are considering whether there can be confidence that it can be fair.
Yes.
Now, what I'm just doing, this is the first example, is indicating, it's actually not the most powerful, I'm going back to move on, but the most, I'm about to give
But
you...
just give me a sort of piece of evidence that that might have been suppressed that's going to be of the faintest interest to anybody at the next trial.
My lord, that is quite an impossible question to answer and is reversing the proper burden. There is such a question mark over the product of this investigation and what has been suppressed that to ask us to tell the court what has been suppressed is quite an impossible question for us to answer.
Well, I mean, the thesis is that the police have acted improperly in one respect, therefore they may have acted improperly in another respect.
Well, not just in one respect. My lord, if you would allow me to, please, my lord, the force and flavour of this will come through when we see this is one of 4 specific examples of D.I. Butler suppressing evidence. And if you get the Deputy Senior Investigating Officer and Disclosure Officer suppressing evidence 12, 13 years later, how on earth can one be expected to be confident that there will be a proper information placed before the court of trial? D.I. Butler tells 206, the CPS, further basically blocking answers to these inquiries, and 208 similarly. He writes the memo at 208 saying any form of reward which Chapman may receive certainly does not arise from this particular case. Now, granted the breadth of knowledge amongst the custody officers and everyone else that there was an expectation of reward for this case from December to...
You're just making over and over again the same point, which I think we understand.
Yeah,
that,
but it's
in relation to Chapman and the inducements offered, the police were probably extremely, on many, many occasions, and now been shown to be actually fine.
I agree myself, you've got some pretty good points, but I'm not sure this is anywhere near one of them. Let's say it is.
My lord, thank you, and that is strong encouragement to move on quickly.
I think you should go to the next of your points if you've got one.
Yes, my lord. Well, shall I just say what they are? Paragraphs 350 to 359 reveal, and if my lord wishes me to put it in a sentence, that there was a very embarrassing taped conversation between Chapman and Daniels, which was a conversation about drugs. A transcript of that was served on the defence, but at 359, D.I. Butler blocked the making of copies of the actual tapes to be served on the defence. And it is no coincidence as those tapes are highly embarrassing, as is clear from from the content of the conversation at 354.
I mean, what I don't quite follow, if I may say so, is if the case goes to a retrial, then the prosecutors will be under an obligation to disclose anything which might undermine their case or support the defence case. And that's obligation they will be under. Now, why should one assume that because things were done badly in the past, they would be done badly on this occasion?
Well, that they will be done badly, you mean, at the retrial?
Yeah.
Is that the question? Well, because...
Why should we not proceed on the basis that the prosecution would behave properly on this occasion?
One should make that assumption, but no matter what the efforts of the future prosecution team, they can't recover what's been irretrievably lost and suppressed. And that's the problem. And the third example, my lord, is where at paragraph 566, D.I. Butler has listened to tape recordings of telephone calls, which are set out at 549 to 564, between Chapman and D.C. Daniels again, and his family, revealing his consumption of alcohol in custody and his consumption of drugs. Now, 566 shows D.I. Butler listened to those tapes and commented, for the purposes of disclosure, brackets, nothing of value. That is straightforwardly dishonest and plainly intended to suppress disclosure of those highly embarrassing tapes. And fourthly, and even more briefly, paragraphs 705 to 706 reveal Butler's role in the suppression of the potential prosecution of Chapman's mother and of Chapman for supplying heroin to Chapman's girlfriend in Style Prison, 705 to 706. So he is key to suppressing evidence, suppressing prosecutions of Chapman, and presenting a false case to the Court of Appeal.
What were the third references? I'm afraid I didn't get them down.
The third was paragraph 566, where he said nothing of value in the embarrassing
Yes, now I've got
tapes.
it now. Yes.
And to complete this, my lord, under encouragement from the court, a good overview is very helpfully given by the court, by the CCRC at paragraph 816, 816. Where the Commission says that they've confined its analysis to of disclosure issues to those which might have impacted on the fairness of the proceedings. And it then lists on this page and over the page 15 areas of important non-disclosure in the case which might have impacted on the fairness of the conviction. That leaves out of account other areas of non-disclosure which may happily not have had that potential consequence. Now, my lord, D.I. Butler is responsible for that. Lord,
is there any reason to think he's going to be a witness at the next trial?
No, but the impact of his suppression of evidence...
You say that he may well have suppressed material which, doing their best, the new prosecuting team will simply not know anything about and not be able to retrieve.
That's right.
That's your point.
Yes, and which may impact on guilt or innocence.
Like what?
Well, my lord...
You mean like pointing that somebody else was doing it instead of these?
Exactly.
I see. Well, I mean, I just want to know what the point is.
But I can only speculate, my lord, and because we can't, because it's been suppressed, we can't point to it. But yes...
This is the unknown unknowns.
Yes, but sometimes, even though it emerges from a rather discredited politician, that is actually a sentiment which has borne the test of time.
Well, I have actually used it in a judgment. That's why I'm referring to it.
Yes. There is a very real danger that there's an unknown here. And yes, my lord, other witnesses to the scene of the crime who saw people leaving in vehicles. And which is undisclosed material, and which in the year between 10th December 96 and this trial in February 98, D.I. Butler may well have said not of value, not to be disclosed, and it's disappeared. Now, Lord, can I look at paragraph 539 of our case, because there is clear... there are clear examples of material very important material that has disappeared and which cannot be restored, no matter what the efforts of the new team. Paragraph 131 in the Statement of Reasons. Prior to the appointment of an investigating officer, the Commission made inquiries of West Yorkshire Police. the Commission sought an informant file for Chapman and all PII material relating to the case, but was informed by West Yorkshire Police that these materials could not be located. Now, granted, the way in which we have seen PII material, so-called, was handled both before the trial judge and before the Court of Appeal, the breadth of that material is potentially very large and significant. It has disappeared irretrievably, cannot be recovered. That is a fundamental threat to the fairness of this proposed retrial. My Lord, further documents have disappeared, for instance, the internal police report on the granting of the reward, but that's less significant than what I've just pointed to. And we've already demonstrated to the court our paragraph 540 in our case, how one can't even be sure about the dates of signing of witness statements, Chapman's being manipulated. And we've seen the elaborate doctoring of the trial custody record. Now, my Lord, we submit that there is no sufficient basis for confidence in the light of this in the fairness of the proposed retrial. We submit that for two reasons, the burden is on the Crown to satisfy the court that there can be confidence in the fairness of the retrial. The first reason is Section 7 of the Criminal Appeal Act itself, which we submit plainly puts any sort of burden on the Crown to justify a retrial. And it's at tab 56 in volume 6, because Parliament has chosen to use the words, and it appears to the court that the interests of justice so require. Now that means that the interests of justice must require the retrial. And other words were not used, such as that it's in the interests of justice. That is a lesser form of wording. So that's our first argument. The second, my Lord, is that we have raised, we submit, substantial question marks over the fairness of the retrial. We've satisfied, as it were, a provisional burden to raise the issue. And it is only right where the misconduct and the suppression of evidence is so covert that the burden then shifts to the Crown to satisfy the court that a retrial will indeed be fair. Those are our two reasons. Now, we submit in the face of all this, the Court of Appeal misdirected itself in rejecting this submission and confining itself to the ability to challenge prosecution evidence.
I mean, of course, I would assume that it would always be open to the defence at any stage in the trial at which it appeared that for some reason you were being prejudiced in some way or other. To argue that the trial actually, as it happens, is not going to be fair, and therefore you can get a stay or whatever it is.
I agree, and that is an additional and normally important and sufficient safeguard. It's not sufficient here because, A, we couldn't demonstrate it during the trial beyond what we've indicated now, and B, the best efforts and the public duty of the prosecution cannot recover what's irretrievably been lost. Well, those are my submissions on that first point. Lord, my second point of the three is as follows. I confess that I made two really rather unhelpful submissions yesterday, and I could have been of much greater assistance in making them. The first was where I starkly submitted, without justifying the submission, that the only lawful answer on these facts is to refuse a retrial. And the second, closely related submission was where I metaphorically put my hands in the air and asked rhetorically, how on earth does a judge approach balancing the different public interests? How can they be measured? Now, there are answers to both those points in our case. I'll tell my Lord where they are, but I'm not going to go through those passages from our case because I bring them together, hopefully, in a more concise and effective way. That's my intention anyway. But I give my Lord the references of where these points are, but I'm going to bring them together and invite my Lord to follow the way in which I put it now, please. Where they are put is at paragraphs 1.48 to 150 and paragraph 5.5.
5 dot what?
5.
5.
Yes, but as I indicate, we bring them together in a different way now, and so I invite my Lord, if I may, to follow our formulation now. Lord, we do invite the court to indicate that the starting point in considering these questions is indeed the alleged offence. There are very good reasons of principle for that. First of all, because an applicant for a stay has the burden of justifying the grant of the remedy. That is common sense, it's the law, ex parte Belsham at volume 3, trab 28 is the undisputed authority.
Sorry, applicant stay has a what?
Has the burden of justifying the grant of the remedy. That's clear. I don't take you to that case, it's standard law and
yes, yes.
Of course correct, it's tab 28. The second reason of principle is that, as Lord Lowry said in Bennett at page 74G, prima facie the duty of the court is to try a criminal indictment on its merits. That is the starting point. And so one looks, first of all, at the nature of the offence, its seriousness, as, for example, measured by its impact on the direct victims and on wider society. That is, we submit a proper starting point. And as a result, and plainly this is a very high example of that, because it's a callous murder, one weighs, as a starting point, the strength of the public interest in there being a trial. One then turns to the misconduct. And, my Lord, one certainly does not simply approach this as a response, instinctive or gut response to it in general terms. We submit there are measures of assessment which apply in this case, and we venture to suggest would apply really in all the reported cases. May we go through them? First of all, the number and rank of the officers or officials involved in the misconduct. Here, of course, it's a very large number and a very high rank. Secondly, their role in the investigation. Here, the senior investigating officer, deputy SIO, disclosure officers, controlling and pivotal role. Thirdly, the number of the instances of misconduct. Here, very large. Fourthly, the nature of the misconduct and its seriousness.
And it's what?
Seriousness. So, for example, whether it is careless or deliberate, whether it is criminal, and plainly it is all that here. Fifthly, any harmful effects or prejudice arising from the misconduct. Here it is profound and extends beyond this case to many other criminal investigations. Sixthly, whether the misconduct was aimed at the integrity of the criminal justice system. here it was. Seventh, what were the duties of the relevant officers which have been betrayed? And here it's of the major crime unit, with extremely important duties to protect the community from the most serious of crimes. And where the impact on public confidence and public cooperation in resolving those crimes is deeply corrosive.
Really overlaps with the first 2 points, doesn't it?
Well,
Number and rank and role in the investigation.
Well, it's intended to be a slightly separate question, Lord. It's aimed at examining the role of the officers more widely in society and in the criminal justice system, and therefore it gives a measure of the prejudicial impact on society and of future criminal investigations of the betrayal of their duty. It's of course overlapping, but it's a slightly different angle on that. It's intended to be. My Lord, eighth, whether there is any justification or excuse for the misconduct. Which might mitigate it morally. So, for example, we take that from two sources. First of all, my Lord will recollect that in Mullen, at page 534, the Vice President asked whether Mr. Mullen was, at the time of the misconduct, the abduction, an immediate threat to national security. And said, well, he actually wasn't at that time. And the other source for this is in loosely the entrapment case at tab 25, where the court asked how difficult the offence is to detect, thus, of course, if difficult, justifying more covert and intrusive police methods of detection. That's from paragraphs 26 and 66 in loosely. But those are mere examples. Put simply, the point is there any justification for the misconduct or partial explanation for it? That's eighth. My Lord, ninth.
Well, just before you leave that, I mean, I don't think anybody in their wildest imagination is going to suggest that this misconduct was justified. But I mean, if you're actually looking, at noble corruption, I mean, this is just such a case, isn't it? I mean, here are presumably the police, they know perfectly well, looking at it through their eyes, you may challenge all this, of course, but they know perfectly well that these brothers are a menace. I mean, we haven't got their record, but presumably, and you've only got, and if they are guilty of these offences, they're a public danger. There's no other way except by corrupting Chapman to put them away. This is in the, I mean, how do you want us to look at number 8 of this list?
In this way, Lord, what was meant was, and was meant by the court in Mullen and loosely, whether there was any proper justification for the misconduct. The justifications...
Well, how can there be proper
misconduct? In this case, this is our very point. Every single one of these boxes is ticked by the facts of our case. There cannot conceivably be the beginnings of any proper justification. And so, but we're giving examples where there can be, but they don't arise in this case. Noble cause corruption is as much a misnomer as honour killings.
The difficulty is that I think the answer is that in every case where there's been misconduct, by definition, you would say, all right, and it's the classic example, the torture example of the ticking bomb. Do you torture if you think you'll get the answer to where it is. But
I understand. There can be no proper justification here. My Lord, there can be some mitigating justification. As in Mullen, why else, we ask rhetorically, did Lord Justice Rose say, well, all right, this is a terrible abduction, but was he actually a security threat which could begin to mitigate, at any rate, the wrong done? And the Vice President asks that. Now,
it's like these cases about where police forces or local authorities, whoever it is, use children to go in and buy cigarettes because it is almost impossible to prosecute the offence otherwise. And there, it may be a wrong thing to do, and you may get involved in all sorts of things, so agent provocateur and so on. But the police or whoever it is say, well, there is actually no other way of catching these people.
My Lord, that's precisely the point. And it cannot. This is such a bad case that there cannot be the beginnings of any such issue here. My Lord, ninth, is there any way in which the rule of law has been or can be vindicated where it's been threatened by the misconduct? And here, as we've indicated, no criminal prosecution of the officers, no discipline. And, my Lord, may I just clarify one thing about civil remedies? I didn't clearly answer the questions properly put to me about potential malicious prosecution. There cannot be an action of malicious prosecution here because the officers are not the prosecutors. This evidence has come from Chapman. All the misconduct is surrounding him, but they're not sitting with Chapman fabricating Chapman's evidence, so far as we know. And there has to be lack of reasonable and probable cause. Almost certainly these officers passionately believed in the guilt of Mr. Maxwell. So there can be no possible action in malicious prosecution. There could be, although it's the most theoretical of remedies, an action in misfeasance for what these officers have done. But my Lord knows how technical and unreal that there is no realistic possibility of civil remedy here, and there's no criminal prosecution, no discipline.
Can we assume, as a matter of interest, that your client's been in custody since the Court of Appeal, but Mr. Mansell was released at the Court of Appeal?
My Lord, that's right.
Yeah.
Yes, I didn't get quite any way. Other way is it the rule of law can be vindicated? Was that what you said? Sorry, was that
that is it?
Yeah.
And the answer here is none. This is point 9. My Lord, point 10 is it a but-for case? Would there have been a prosecution at all but for this misconduct? Plainly here, this is a but-for case. I've only 2 more to go. 11 is, does the misconduct involve a violation of a basic human right? Plainly it does here. The whole right to a fair trial was destroyed. And finally, 12, was the misconduct concealed? If so, for how long? And did the concealment involve perjury? These are issues that arose, of course, in Mullen, concealment for 10 years, and in Early. And plainly, this is a very bad example of that. And the worst possible is where the opportunity within an ex parte hearing to deceive the court is used in the absence of the defence and abused. Now, my Lord, this case ticks every single one of these boxes strongly. And these are the kinds of questions which can break through the kind of difficulty I was expressing yesterday. How does one assess? These are criteria which, of course, to varying degrees, can be applied, we think, to every single one of these reported cases. Now, my Lord, I've another stage to this, which is shorter, but still important. We submit it is striking in this case how one can stand back, having made this assessment, and look at what are the established criteria for the grant of a stay and see how much this case exceeds those criteria. 4 ways. First of all, as Lord Griffith said in Ex parte Bennett at 62A. It's only one sentence, but if my Lord wishes to look at it, it's tab 23 in volume 2, page 62A, but I'll just read it to my Lord. Tab 23 in volume 2. Page, the very bottom of 61 and then the top of 62. Yeah. If the court is to have the power to interfere with the prosecution in the present circumstances, it must be because the judiciary accepts a responsibility for the maintenance of the rule of law that embraces a willingness to oversee executive action and to refuse to countenance behaviour that threatens either basic human rights or the rule of law. Now, not all cases will do both. Either could do, but this case does both. So that's, as it were, criterion number one, satisfied beyond what is required. Secondly, we submit this case, this misconduct struck at the heart of the original jurisdiction to protect the process of the court from abuse. That is the original jurisdiction, which predated its extension in Bennett to investigative misconduct before and outside the process of investigation and the conduct of the trial. So,
would you care to restate that? This misconduct struck at the heart of the original jurisdiction to do what?
The original jurisdiction to grant a stay, which was to protect against the abuse of the process of the court, which is what Lord Lowry emphasises was the original purpose. And it was Bennett which extended it to executive misconduct outside the actual process of the court.
So that's circular in this case, isn't it? I mean, it assumes what you've got to prove, namely that the fresh proceedings would be an abuse. In all the previous cases, the fresh proceedings were abusive because there had been, for example, previous proceedings on precisely the same point, or the man shouldn't have been there at all.
I understand. I'm not, my Lord, focusing now on the proposed retrial. I'm looking at what happened at this trial, the first 90...
How does stopping a retrial prevent abuse at the first trial?
It doesn't. I'm not asking that question for the moment. I'm just looking... well, it's not going to deter it. It's happened, etc. No, I agree. But forgive me. The point I'm making is really quite different. We are entitled to look at the established misconduct and its impact and its effects. And here, this was aimed at and successfully destroyed the integrity of the court process during this 1998 trial and 1999 appeal. That is at the heart of this original jurisdiction. That's all I say. It doesn't have to be, but it is. And my fourth point, my third point here is that on the authority of Grant, there does not have to be actual prejudice from the misconduct, but here there plainly is, both within this case and the associated cases, Jennings and the drugs prosecutions, etc. So it exceeds the criterion for the grant of a stay there, if Grant is correctly decided. And fourthly, this is a but-for case, even though it doesn't have to be, for the 14 reasons we gave yesterday. But-for is not a touchstone test, although it's a relevant factor. This is a but-for case, even though it doesn't have to be. So, my Lord, putting together those 12 aspects of the misconduct and measuring, using those 4 measures within the broad, the parameters of the potential grant of a stay, this case is far worse than any of the reported cases, any of them.
These are, let me just get straight. I mean, these are what criteria for a stay of the original proceedings you're talking about, or criteria for a stay of the fresh proceedings? Because
That's
some of
the
them...
second.
Yes, I say, well, we come back to my point that the first two tend to, don't they, beg the question. We've got to... I can see that the conduct threatened human rights and the rule of law in the original proceedings. I can see that it struck at the heart of the original jurisdiction, or a stay would have... that it related to abuse in the first proceedings, but I don't see that what we've got to demonstrate is that that's the case in relation to the second proceedings, the fresh...
No, we don't. No, we don't. My Lord, we haven't yet asked. My Lord, it is taking me to the crunch question, which is not a bad thing to do. The crunch question is a prospective one. It is looking at whether the proposed trial or here retrial will damage the integrity of the criminal justice system. That is the ultimate question. And we are at, well, I've come to the end of the assessment, A, of the seriousness of the offence and the public interest in a trial on the merits, and then B, the qualities and impact and etc. of the misconduct. One only then turns to the proposed trial or retrial when asking the crunch question in the light of both those factors. And we have no hesitation in saying that the only lawful answer, the only proper answer, in the light of all these factors, to the question of whether a proposed retrial in these circumstances would damage the integrity of the system of justice, the only lawful answer is yes. Because every single one of these 16 boxes is ticked. Now, my Lord, my third point will be quite brief, and it's whether this is whether these confessions are compelling evidence. Compelling is defined in the Act. My Lord, you have the Act in Volume 6, tab 58.
This is the 2003 Act. Right?
It is indeed. And it's Section 75, which establishes the power for the Court of Appeal to order a retrial after an acquittal.
Which includes an acquittal on appeal.
Well, or acquittal at trial.
Yes, or one or the
absolutely,
other. Yeah.
Absolutely. And although this was not a necessary step to be taken, our Court of Appeal adopted this by analogy as a standard to apply to whether to order a retrial in this case. And they did it at paragraphs 28 and 29, and Prosecution Counsel agreed. Now, Section 78...
It is accepted this Act doesn't apply.
It does not literally apply. It's by analogy that the Court of Appeal applied it.
And do you say they were right to do so?
We say it is entirely permissible, and we consented to it.
But if they hadn't done that, would they have been wrong?
Would they have been wrong? Well, they would have been wrong not to apply a high standard to the evidence to be called in this retrial before ordering a retrial in this case, and this is a good way of expressing it. So they would have been wrong not to apply this analogy or something like it.
Before the 1968 Act, the rule against double jeopardy would have even prevented the Court of Appeal ordering a retrial, would it?
No, Lord. For this reason, that, forgive me, it's not the rule against double jeopardy. There was no statutory power to order a retrial at all, and that caused all sorts of anomalies, and that was a problem in common with DPP. So we then have a statutory power to order a retrial upon the quashing of a conviction, which came in Section 7, 1968 Act. In fact, I think it came in the 1966 Act. 64 Act. It came in shortly before and was consolidated in the 68 Act. Thank you very much.
So the power to order a retrial on the allowing of an appeal against conviction came in 64.
It was extended, wasn't it?
Yes, my learned friend Mr. Perry really does help me on the history, and I do rely on him. It was originally quite a restricted power, which depended on there being fresh evidence. Yes. It then became the more general discretion we see in Section 7. So, my Lord, that's the development of the general power to order a retrial after you've quashed the conviction. Now, the distinction between that and the 2003 Act is that it applies where there's been an acquittal at trial or an appeal, a successful appeal in which the conviction has been quashed and arguably a verdict of not guilty entered, and then you come back later with compelling and fresh evidence.
So this is about the rule against double jeopardy?
This is, absolutely it is. And so, my Lord...
What does acquitted mean here?
Forgive me, my Lord.
What does it mean, acquitted?
Well, it applies under subsection 1.
I see that, yes, but...
On indictment or on appeal against a conviction, verdict or finding, well, my Lord, acquitted will mean where there has been a prior successful appeal against conviction and the conviction is quashed.
Well, that's what's happened here. But...
Yes, I agree, but the court has the statutory power under Section 7, general discretion, but the court is, as it were, voluntarily restricting it in the particular circumstances of this case to cases of fresh and new and compelling evidence.
I mean, this applies. I think we all know this is intended to apply where something happens afterwards. Once the whole thing is over, something happens afterwards and it comes back. Whereas we're not really in that territory, but you're happy, you say, and you think it was a good criterion for them to apply.
Yes, I mean, London Friend's position is that it wasn't necessary for this to be adopted. It's a marginal difference between us. We say something like this should have been approached. My Lord, because really of the public policy and the finality of criminal litigation. Otherwise, you'll have 2, 3, 4 bites of the cherry by the prosecution, which is quite contrary to public policy.
But, so you're not saying this applies in all cases, do you, of retrials?
Not at all. No. I mean, it's being applied by analogy here because the court has come and made this retrial application not with clean hands.
The prosecution has.
That's right. Thus, a high barrier is applied by analogy by the Court of Appeal in fairness. That's why the Court of Appeal did what they did. And having adopted this standard, we submit they misinterpreted what compelling means. Can I take you to the definition of compelling in the Act, section 78.2, 78.3. It has to be new, then it has to be compelling. Evidence is compelling if A, it's reliable, B, it's substantial, C, in the context of the outstanding issues, it appears highly probative of the case against the acquitted person. Now, my Lord, may I make a concession? On the face of these admissions, if one interprets the word compelling in this Act as an ordinary word in the English language, one could certainly say these admissions are compelling on their face. But, as 2 decisions have pointed out, there are very good reasons for looking quite strictly at what compelling means. And those reasons are precisely to do with the public policy and the finality of litigation and the exceptionality of this procedure. Can I take you, please, to paragraph 6.5 in our case? And to save time, we've cited all the relevant passages, not go directly to the authorities. Paragraph 6.5, case of Andrews, where this was a case where the respondent had been acquitted of sex offences, but as a result of a newspaper article, a mass of other evidence of similar complainants arose, which allegedly transformed the picture. And the court ordered a retrial, finding that was compelling material. But the Lord Chief Justice said this, looking back at the Law Commission and its reports before the 2003 Act, paragraph 25 from the judgment, Law Commission gave 2 examples of what were seen as the strongest possible cases of reopening and acquittal, DNA and a hit woman who comes forward after the acquittal of those who hired her. When the Law Commission reported, it referred to cases where new evidence of the defendant's guilt becomes available, and it gave us examples of full and uncontestable confession, evidence of a scientific nature, the weapon with the defendant's fingerprints being found in his home or garden, and CCTV footage. The director has indicated that he would only proceed in cases where, as a result of new evidence, a conviction is highly probable and any acquittal by a jury at a subsequent trial would appear to be perverse. We believe that this guidance is entirely appropriate and consistent with the relevant legislative framework and reflects a proper appreciation of the continuing, but not absolute, importance of finality in the criminal justice process. My Lord, the next paragraph in our case is a separate dictum from, I think it's Lord Justice Hughes in GG and BS. More recently, this was a case actually where the defendant had been acquitted of a shooting and one of his co-defendants turned around, having been convicted, and said, look, I'll give evidence against the person who's been acquitted. Paragraph 5, the bar for the Crown is, as its counsel rightly recognises, a high one. In particular, it's not enough that the new evidence presents the defendant with a case to answer. The time to present him with a case to answer is at the time of his trial. There are very powerful reasons why there ought normally to be a single trial at which all the evidence is assembled and assessed, and which produces an outcome which, whether conviction or acquittal, is subject to any error of law or principle exposed on appeal, final. It is only where there is compelling new evidence of guilt of the kind which cannot realistically be disputed that the exceptional step of quashing an acquittal will be justified. Now, we submit that apparently impressive though these confessions are, and plainly providing a prima facie case, they can realistically be disputed and an acquittal wouldn't be perverse.
Isn't one putting a bit of a gloss on the language there?
Yes.
I mean, is that justified? It appears highly probative. And isn't it also slightly rosy? I mean, I hate to say this about much more experienced criminal judges, but it's a slightly rosy tinted picture, a full and uncontestable confession. What confessions were ever uncontestable when one got to court? Evidence which cannot realistically be disputed. I mean, almost any of this evidence one knows is capable of being very substantially disputed in a jury trial in this jurisdiction.
Yes. Well, my Lord, I started by conceding that on the ordinary meaning of these words, these confessions probably qualify. And the reason for putting a gloss on them is because this is an exceptional jurisdiction on the public policy and finality. Now, I agree that these are mere examples, but a confession could be realistically uncontestable, where it leads, for instance, to the finding of some critical evidence where it discloses special knowledge, as the test is. Knowledge which only the guilty person can have...
I see that, but I mean, should courts be taking very carefully drafted statutory language and actually redrafting it?
Well, my Lord, we submit it's not. It is a conventional tool of statutory interpretation to examine the policy context for Parliament's legislation. And this is why both the Lord Chief Justice and I think Lord Justice Hughes is now the Vice President.
Yes, he was the Vice President at the time.
Yes, it is a gloss. It is a gloss.
I just question whether this is the right approach here. We're not actually in Section 75 territory.
No.
We are concerned with Section 7 of the Criminal Appeals Act. Yes. And there's no question of the finality of litigation and so on. Is actually that there are huge inroads by definition into that principle of finality by giving the power to order a retrial where the interests of justice so require. And surely the only question is whether the interests of justice do so require on the facts of the case. And so whether the Court of Appeal has or hasn't gone too far in interpreting Sections 75 and 78 in the way they have, I would have thought really is neither here nor there.
Well, my Lord, with respect, that does really echo, I think, my learned friend's approach to this. It was not necessary for the court to adopt this approach.
I mean, Section 75 is a gloss on Section 7, and then you add a couple of authorities as a gloss on 75. I mean, we're getting further and further away.
I mean, surely it's good enough for you. So do the interests of justice require?
Well, that's it.
That's surely
I'm grateful, and the burden that implies, and my lord, that would import. I mean, I do submit we are in finality territory, because finality comes into the picture here, because the state has used and utterly abused its one proper opportunity to obtain a fair trial on the merits. And that's where the principle comes in. It is quite exceptional, granted this history and that misconduct subverting that opportunity, to grant the state a second bite of the cherry. So finality is the background, and it blends in really, if one just goes back to Section 7, with the requirement that the interests of justice must require the retrial. And that carries a flavour of a burden of justification. And that will then bring in we submit a high standard, whether we're applying Section 78 or not, a high standard of material to justify the state getting a second bite of the cherry. And my lord sees, I really think I should sit down, but my lord sees how we put our submissions that these confessions are not incontestable or not realistically incontestable, and acquittal would not be perverse, and they are not truly compelling, if one interprets that word in its proper context. Or, going back to Section 7, why in the light of this proposed evidence a retrial is not required by the interests of justice. And certainly the CCRC itself assessed these confessions as being highly unreliable, self-serving, inconsistent, and aimed at the self-interest, whatever it may be at the time, of Mr. Maxwell. And that appears, our paragraph 612, from those paragraphs we refer to there, 904 to 915 in the CCRC's report. Of course, there are many retractions, etc. My lord, I've overstayed my welcome, but I've been, on the margin of discipline, I've been sort of 7 out of 10 rather than 2 yesterday.
Thank you very much indeed.
Thank you very much.
Mr. Sherritt. Yes, Mr. Perry.
Yeah, may it please your lordships, our submissions are set out in the written case that we prepared for the purposes of the appeal. For the purposes of our oral submissions, may I adopt, without repeating what is set out in writing, and begin our oral submissions by making some general observations in relation to the approach to this appeal. Lord, the first general observation is that we submit that the appellant's arguments are over-elaborate as to the tests to be applied and the factors to be applied. They would inject complications into the trial process, and if accepted, would not satisfy the fundamental criteria that should guide any court when considering questions of criminal law, namely that the criminal law should be clear, of certain application, intellectually coherent, and of general and easy applicability.
Just say those again. Clear,
Should be
of certain
clear,
application.
of certain application, intellectually coherent, and of general and easy applicability. Lord Mayor,
General and
easy applicability.
easy?
Easy to apply, my Lord.
Easy applicability.
Yeah. Lord, may I just give one example of what we mean by that, because these are the sort of arguments that are being deployed in criminal courts in England and Wales on a daily basis. Take the argument that was advanced to the court yesterday about the man who confesses, not in the circumstances of this case, but in the pages of a book written for profit. And it was suggested to your lordships that that person would forfeit any sympathy and there would be some moral equivalence between state misconduct and the state misconduct of the author of the book. But we submit that fine distinction would be impossible to apply and in fact makes no sense. How would it apply if the person decided to write the book but donate the proceeds to charity? How would it apply if a person makes a confession but not in the pages of a book but in immoral circumstances? And we submit that in this case, as we've set out in our written case, that your lordships may wish to consider whether the law in this jurisdiction might usefully follow the approach which has been adopted by the Supreme Court of Canada in the two decisions, Tobias and Regan, which I'll come on to in due course.
Well, just before you do, page 23 of your printed case, Roman 3, which is the principles you derive from Regan, is there a not missing, or have I misread it, or what?
It must be.
It would be helpful if we're going to have this clear, intellectually coherent certain application. If we had the knots there when they're meant to be. Are they meant to be there?
Third line in the middle.
That's right.
Yes. Yes, I'm sorry, my lord. Which does not. Yes. My lord, I'm going to take the lordships to the statements of principle in the cases, but it appears as though, so far as the overseas jurisdictions are concerned, that where abuse of process has been considered by the courts in overseas jurisdictions, there has been a broad consensus as to the type of principles that ought to be applied when considering the question of whether a stay of proceedings should follow misconduct.
Do you accept the same principles apply to retrials?
Not always, my lord. They may in some cases, because take, for example, a Bennett-type case, where, suppose it's a Bennett-type case where you've stayed the proceedings, it would be pointless ordering a retrial in a Bennett-type case.
Because exactly the same.
Because exactly the same position would apply. But, my lord, I don't accept in this case that we're in that sort of situation for obvious reasons. And if there's any criticism, I don't make any criticism of the Court of Appeal, but it was not necessary for the Court of Appeal to engage in the elaborate exercise of looking at sections 75 of sections and to 79 of the Criminal Justice Act, a statute outside the Criminal Appeal Act, for guidance as to how to exercise its powers under section 7. And the difficulty that can create is in fact exemplified by this case, because if you'd simply applied section 7 and interest of justice test, it might be thought that you'd have ordered a retrial in both appellant's cases rather than simply this appellant's case. But because they put in place the high threshold which operated in favour of this appellant, then they applied a high threshold, and we submit that they should not be criticised for that.
But you're going to take us to Tobias and Regan, which were both stay cases.
Yes, Lord,
I, for one, would like to know if there's going to be any difference between retrial cases of this kind and stay cases.
Yes. Lord, I suppose the way to conceptualise it would be that if you're simply returning someone to the Crown Court and the position remains exactly the same, then you have, looking prospectively to see whether you just achieved the same result by the time you had the retrial. That's Bennett would be the classic example of that.
I'm sorry, you say that but for the Section 75 approach, there would have been enough here to put Mansell on retrial too?
Well, my lord, I would submit yes. Because
On the basis that he was together with him or something?
Well, the evidence, putting Mr. Chapman to one side for the moment, the evidence in relation to Mr. Mansell came from a civilian witness who identified him at the scene of the robbery on the 13th.
Where do we see a useful summary of the evidence, apart from Chapman, against these two men at trial?
Well, my lord, I can come on. There's something in the Criminal Cases Review Commission report in relation to the other evidence, which is volume 2.
A convenient summary of it would obviously...
Other evidence.
Yes, where do we see
it? Page 52.
Internal page?
Internal page 52 of volume 2 behind divider 6. There's, at paragraph 23, the prosecution adduced evidence from Mrs. Adams. That's Mrs. Elaine Adams. She was near the premises.
Well, where do we... I mean, you're telling us things. I want to know where we find them, apart from these 3 paragraphs.
Well, Lord, may I give you the references also to...
Sorry, could you just... most of my internal numbering seems to have been photocopied out.
Page 52.
Page 52 of the bundle.
52 of the bundle.
Thank you. Yes, thank you.
But, Lord, I can give you the references to where this is also dealt with in the summing up, if that would be of assistance to your lordships. Lord, the identification at the scene by the civilian witness Elaine Adams is volume 3, internal pages, page 522 to 534. So that was the first piece of evidence. Then there was a shoe print which matched the shoes that were recovered from Mr. Mansell when he was arrested the following April. The shoe print was found at the scene of the robberies. That's dealt with in the summing up, volume 3, page 541 to 549. So that would be the starting point. When the defendants gave evidence, they both accepted that they were in each other's company. That's not a disputed fact. I'll get a reference for that, but it simply was the basis upon which the case proceeded. But, my Lord, there was also the fact that the defendants had put forward a false alibi for the 13th of October, the day of the second robbery, when the murder was committed, and that's dealt with by the learned trial judge, summing up volume 3, page 535 to 538. And in addition to those pieces of evidence, if you did want to present a case and without relying on Mr. Chapman's evidence, it would be possible to establish the connection between the appellant and Mr. Chapman. For example, you could, on a retrial, have adduced evidence that they were together in prison. You could then establish the connection between Mr. Chapman and the burgled premises. So you'd establish that the appellant was in prison with a person who could be connected with the burgled premises, and but he, of course, could not have committed the burglaries because he was in prison, Mr. Chapman. And there was also evidence of an A to Z, which had the appellant's fingerprint on it, with addresses marked in it, and that is dealt with in volume 2, it's volume 3 in the learned judge's summing up, pages 557 to 568. 1965. And, my lord, the significance of the A to Z was this, that the burglaries took place in an area that was known to Chapman. But the appellants came from Lancashire, the burglaries taking place in Stanley and also Chapeltown, I believe. And the point being made was, because the A to Z had the appellant's fingerprint on it, this was Mr. Chapman, in effect, telling him the premises that were vulnerable to burglary, because, of course, Mr. Chapman would not need the A to Z because he'd already burgled the premises. And there was also...
So where was the A to Z found? How did it link with Chapman?
Lord, that was seized from the prison. It was still with Mr. Chapman.
I see.
But
yes, had the appellant's Maxwell's fingerprint.
It was linked to the appellant by a fingerprint.
Yes, I see.
And then there was another piece of evidence in relation to a piece of paper that was in the appellant's possession, which did not exist by the time of the trial, but witnesses gave evidence, or one witness gave evidence, that it had been in the appellant's possession and it had Boris and a foreign-sounding name on it. And the Boris, there was an address of a Boris Pukach, P-U-K-A-T-S-C-H.
Sorry, spell again.
P-U-K-A-T-S-C-H, my lord. That was also a premises that had been burgled by Chapman. So here was a link between the appellant and another address that Chapman knew was a premises he'd burgled.
Now, the other thing I want to ask you, do we have any record of the previous convictions of these two men?
My lord, not in these papers, but I can arrange.
Why not? I mean, presumably the Court of Appeal did. Is it suggested that that's not relevant to whether or not? Anyhow.
Well, my lord, I'll arrange for the previous convictions to be provided.
Do we have a reference in the summing up for the piece of paper evidence?
The Boris evidence.
Boris evidence.
Yes, my lord. It's volume 3, page 566 of the bundle, page 571.
Thank you.
It's summarised on paragraph 15 of the report as well.
I'm grateful, my lord. And, my lord, there was also, significantly, just pointing up the links between the appellant and Mr. Chapman, on the day of each of the robberies, there was telephone contact, and this was admitted. It was proved by the telephone records. The appellant had telephoned Mr. Chapman on each of the occasions of the robberies. That's the 11th of June and the 13th of October. Can you get me the reference to that?
Paragraph 14 of the report.
Yes, and Lord, there was also the appellant admitted in the course of his evidence that he carried out a reconnaissance at another premises, the premises of Bertha Bell, which is paragraph 10, and page 50 of volume 2, and going over the page. Thank you. So, Lord, I hope that's... Lord, that is the way. If there had been an order for a retrial, taking out the evidence given by Mr. Chapman that the prosecution could have presented a case against both appellants without relying on any of the tainted evidence at all. Lords, may I just then make these additional points by way of general observations, and that they relate to some of the principles from the case law, which we say are really uncontentious. But the first point, Lord, it's a point made in all the cases. A stay of proceedings is an extreme step which is only to be taken in the clearest of cases. As the appellant concedes, this really follows from the fact that the stay is in essence a power vested in the court to refuse. It's a power vested in essence, my Lord. It's a power vested in the court to refuse to exercise a jurisdiction it would otherwise be having. So, as Lord Lowry put it, prima facie, the obligation is to try or determine the criminal charge. The second general principle, Lord, that we say is important is that a stay of proceedings is a prospective remedy. It is not backward-looking. And we submit this is important because, as the case law makes clear, it does not seek to redress a wrong already done. It is designed to prevent the continuation or perpetuation of a wrong. And in this case, the Court of Appeal finding was that the evidence of the appellant's admissions were untainted by the previous misconduct. See the Court of Appeal judgment, paragraph 67, which is in the operative part of its judgment, paragraph 67, untainted by the previous misconduct, and we submit that that was the correct analysis. Lords, we also submit that another general principle is that the power of a stay is not available for disciplinary purposes, and nor is it available to reflect a court's view that a prosecution should not have been brought. The courts have not approached the remedy on the basis that it is a general deterrent. If it is anything, it is a specific deterrent aimed at preventing the continuation of particular misconduct. And in this case, the misconduct has been neutralised and remedied by the quashing of the conviction. So we're now looking prospectively at what will happen at any future retrial. And the other general point at this stage, my Lord, before I just go very quickly to some of the overseas jurisdictions.
It's quite a difficult distinction. I find it quite difficult. I mean, I know that you say in Bennett-type cases, it sort of continues because the chap's there, and he would never have been there if he hadn't been for the... But I mean, the misconduct is in one sense over and done with. I mean, whatever they did, they did. And now the prosecution is just going on leading evidence and so on. I mean, I find it quite a difficult line to draw.
Well, my Lord, it's also... What is motivating the courts here is the fact that it is such a dramatic and drastic remedy to stay proceedings. And of course, my Lord, ordinarily, if it were just a challenge to misconduct which enabled you to sever out from the case or carve out from the case the tainted evidence, and you could proceed with the case without that evidence, then the courts are told that's what they should do. the stay of proceedings is the ultimate remedy. Now, even in the United States, where you have a fruits of the poison tree doctrine, the United States courts have found it difficult in the public interest to apply that doctrine strictly. And what they have had to do is develop what's known in the American case law as a dissipation of the taint. Now, the exclusionary rule in the United States is a deterrent, is largely based on a deterrent rationale. But even there, where it's a deterrent rationale, the courts have found that you effectively have to carry out a cost-benefit analysis, taking into account the public interest.
But that's in a completely different context. That's exclusion of evidence. There's a completely different line of authority in relation to mistrials caused by prosecutorial misconduct.
Well, but Lord, it's absolutely right that it's dealing with the exclusion of evidence. But the point in relation to even where you do have a fruits of the poison tree type doctrine, the courts have found that it can operate too austerely and have developed mechanisms to permit trials, cases to be determined on their merits. Now, if the remedy is seen as really one that looks prospectively, we submit it's much easier for judges and practitioners to apply. And that is the merit of having this approach of saying you don't look backwards, it's a prospective remedy, and you're not looking to deter, it's not a general deterrent, and to the extent that it is a deterrent, you've remedied the misconduct by quashing the conviction.
But Maxwell's subsequent confessions were, in a sense, at least in one sense, the fruits of the misconduct, weren't they?
Well, my Lord, we wouldn't accept that it's right to apply some but-for test in this context, either when you're looking at but for the misconduct there wouldn't have been a trial, or but for the incarceration he wouldn't have made the admissions, because it was up to him what he had to say to people when he was in custody. And a but-for test would be very, very over-inclusive and very wide to apply. And ordinarily, where you apply a but-for test, there are limiting conditions, because you're saying, well, but-for, but you can limit but-for by looking at the state of mind of the defendant. In a criminal context, ordinarily, where you're applying a but-for test in relation to criminal liability, mens rea is a limiting condition that means that but-for is not exorbitant. You can't say but-for the strangler's grandparents, the murder wouldn't have been committed, therefore the strangler's grandparents are guilty, because you've got all the other controlling conditions. But we submit that to introduce some but-for test would be very wide in this context. And we say if you just look prospectively, as it appears that they do in overseas jurisdictions, and you just see whether the taint is going to be perpetuated or aggravated by the trial, then we say that's not the position.
But I mean, how can you say it's not going to be perpetuated in the sense that, but for the prosecutorial gross misconduct here, there never would have been a trial, there certainly there never would have been a conviction on the basis, there would never have been a rejected first appeal. And so it is that you have a man who, on the state of evidence that we now know it to have been, shouldn't have been in prison, shouldn't therefore have been, wouldn't have been, logically, making this series of apparently wholly incriminating confessions. I mean,
well,
you know, how do you untaint?
One could take an extreme example there. I mean, supposing the misdeeds had come to light and the convictions quashed, and then outside court he comes out and he said, well, thank goodness that's over. Actually, I did it, but I'm now free. Surely you wouldn't then exclude that evidence. He would be put up for trial a second time.
And my Lord, you wouldn't...
But you never said it but for the original misdeeds.
Well, my Lord, that's why we submit that but for is an unsatisfactory type of test. The way this would be, the way this is approached in the Canadian context, as you say, is the abuse carried forward? And if it's not, no difficulty. If it is, then you carry out a balancing exercise having regard to the... So I'll deal with this.
I mean, the dissipation of the taint, I suppose it might be of some interest, though one doesn't want to get into it, but if there were some suggestion that it was... and I think there is a suggestion that some of the things were said tactically because of the predicament he was in, then one would find oneself in a situation where there was an obvious causal relationship, a bit more than a but-for causal relationship between the confessions and the original problem.
Well, Lord, in relation to that, certainly the Court of Appeal in the operative part of its judgment approached it on the basis that because of the situation he was in, that's the way the Court of Appeal approached it. So they took that into account. But nevertheless went on to say that the public interest lay in favour of a retrial. And we submit that was the correct conclusion to reach, because when you're confronted with clear confessions over a period of time made to solicitors, volunteered to people investigating bogus official burglaries, and made to the North Yorkshire police who were investigating the misconduct in this case, then we submit that the court can properly say that it's not evidence which is tainted by the earlier misconduct, and you can properly have a retrial. And Lord, that when the appellant finally admitted it in relation to the North Yorkshire police officers, there was a period of time when he was denying it, knowing that they were investigating the allegations in relation to the trial. And then the North Yorkshire police officers who were investigating obtained the solicitor's file from the solicitor who'd been representing him back in 1998, before, of course, the first Court of Appeal hearing. And when that was put to him, well, you were even saying to your solicitor before the Court of Appeal hearing back in 1999 that you were guilty of the offences and that you had been present at the robberies, you were guilty of robbery, but you wanted to run a manslaughter appeal. He then said, yes, I was there, and then gave a full account.
Why aren't those confessions regarded as confessions to robbery and manslaughter rather than robbery and murder?
Because, my Lord, when he gives the confessions, he contemplates the infliction of serious harm in the course of the robbery. And, of course, although he says it's his brother who inflicts the fatal injury on Mr. Smales, the appellant's contemplation of the infliction of serious harm in the course of the joint enterprise attaches him with liability to murder.
Well, I follow that. I thought certainly one of the confessions, he says he didn't contemplate either of them doing anything that would involve serious injury.
Well, but Lord, he does say that, but at the same time says that he punched one of the brothers on the nose and heard it breaking, and that he gives two different accounts, but he says that the brothers, when they burst in, had scissors, one of them had scissors held up against his throat. And clearly it was within their contemplation when they went there that these were vulnerable men who would have to be subdued if they resisted the burglary.
How old were they, the Smells brothers?
One was 64 and one was 85, my lord. I'll check that. The one who died was 85.
85?
85, my lord. And I believe the other one was 64.
Do you accept that if the admissions were not admissible, the trial couldn't go forward?
It would be very difficult, my lord, but it would. For our part, we believe that you could construct a case here. Of course, with the admissions, it's much stronger because you've got all the other evidence that you've got. I mean, you could, once you've got Mr. Mansell at the scene and this appellant's admission that he was with him on the relevant days, plus all the other links that I've mentioned, you could say that the appellant would have to go into the witness box to explain that away, and if he didn't, he would have an adverse inference direction made in his case. But it would be difficult, much more difficult without the admissions.
Well, there's no doubt what the decision of the Court of Appeal would have been in this case.
Yes.
But for the confessions.
Yes. But my lord, that we know that, my lord, because they were applying the new and compelling evidence test, which we submit was unnecessary.
Yeah.
But if it was unnecessary, it was in the appellant's favour, and therefore the Court of Appeal shouldn't be.
Wouldn't you accept that the likelihood of a conviction on the evidence that would be adducible at a fresh trial must be a highly relevant factor in deciding whether, in this sort of context, against the background of gross prosecutorial misconduct, whether there should be a retrial at all?
My lord, certainly that is a factor, my lord. But there's also another factor, and it's really the point that was being debated yesterday about the purpose of criminal proceedings. Because even if someone has served all their sentence, and they're not going to get anything more if there's a retrial, it still may be right to order a retrial because there is a public ascription of liability, or possibly not if someone is acquitted. Because one of the points that is made by the High Court of Australia in one of the decisions when it considered whether to order a stay was the fact that it doesn't necessarily undo the anxiety that a defendant faces, because it may still leave the cloud of suspicion hanging over a defendant. And there's something very important, as Professor Duff and the others put it in the Trial on Trial, something very important is lost when you don't have a determination on the merits, whichever way it goes. The very important thing that is lost is a public announcement of whether someone is or is not guilty, whichever way it goes. But, my lord, I do accept that the likelihood of being convicted is obviously a material factor as well, but not the only factor. And we would submit here that there's very, very strong evidence. There's very strong evidence based on the admissions. Is what we would say.
I'm sorry, I'm not quite sure I've entirely understood your position. Supposing I'm in the Court of Appeal and I'm deciding whether to order a retrial. I've just quashed the conviction on the grounds of all this misbehaviour by the police. I'm now deciding whether to order a retrial. I look at the evidence and so on and so forth. Yeah, there's enough there. Do I or do I not take into account the misdeeds of the prosecution, of the police?
Lords, if there is nothing,
Well, you say there's no continuing thing. You
Yes.
say there is. I mean,
Yes.
that's your position, as I understand.
Yes.
Now, if there is nothing, if the evidence is, supposing it could be done without
Yes.
without the confessions or something like that, but supposing there's enough, do I or do I not say, well, I take into account the fact, because I thought you did say in reply to Lord Brown that it was a factor to be taken into account, but I don't understand on your approach why it is. Because you, as I understand it, your whole thing is prospective. Now, I'm not saying you're right in that, but I'm just trying to understand what your position is.
Well, my Lord, I wasn't limiting it, my Lord, to stay applications, but generally orders for retrial, not necessarily in this context, but when the Court of Appeal is exercising its powers under Section 7 of the Criminal Appeal Act. And, Lord, the position is, we say, if going forward there is no taint, then that's all that needs to be considered at that stage, subject, of course, to the ordinary test in Section 7 of whether it's in the public interest. But if you've got no taint, then it's not necessary to look backwards.
So the whole thing has been washed by the setting aside of the conviction. Is
Yes.
that right?
Yes.
So it couldn't matter less how much misconduct there's been and how outrageous it was to have secured the conviction on the original basis. You say? I mean, just forget all that. There it is. He's made some admissions.
And you go forward, my Lord, on the basis that you can have a trial which is untainted, and the public interest would always lie in favour of a trial that determines guilt, that's where it can take place without tainted evidence.
Well, it makes a complete nonsense of cases like Grant.
Well, my Lord, my Lord.
I mean, you may be right to make a nonsense of Grant.
Well, my Lord, if your Lordships asked me whether I consider Grant to be correctly decided, I would say it was incorrectly decided.
I mean, they certified a question. What happened then?
But, Lord, I'm not sure whether it was ever pursued to your Lordship's house, but, Lord, one of the unsatisfactory features we would submit of Grant is that it appears to be premised that under the Regulation of Investigatory Powers Act, you could never eavesdrop on conversations between a detained person and his legal representative. But your Lordships, the House of Lords decided in the McKee case that the case from Northern Ireland, your Lordships will record, your Lordships, some of your Lordships decided in the McKee case that the Regulation of Investigatory Powers Act did permit eavesdropping in police stations and detention centres. What the problem was in that case, that it was directed surveillance within the meaning of the statute rather than intrusive surveillance. And your Lordships, the House of Lords held that to be proportionate, it had to be intrusive surveillance rather than directed surveillance. And
Oh, that's rather odd. How does that... Well, I wasn't in the case, but I mean, intrusive, we all know, is more intrusive than... It has to be in a home or the car, I think.
Yeah, well, Lord, the reason why it had to be designated by the Secretary of State as intrusive surveillance was because the thresholds for authorising it are stricter. So you build in more safeguards if it's intrusive surveillance. So the House of Lords held that it was permissible to carry out eavesdropping of conversation subject to legal professional privilege if it was authorised as intrusive surveillance rather than as directed surveillance.
I see.
Now, my Lords,
But it hadn't been authorised on a high enough level in Grant.
well,
Or perhaps it hadn't been authorised at all.
well, it was unclear, my Lord, whether it had in fact been properly authorised at all. And the trial judge in Grant had made a finding that it had not been done dishonestly, or the police officers had not behaved dishonestly, whereas the trial judges in two other cases had found that it had been done dishonestly, and the Court of Appeal said that they could take those other decisions into account to cast doubt on the finding reached by Mr. Justice Astill, who was the trial judge in that case. But, my Lord, we do say that grant is an unsatisfactory.
Do you go as far as say, if there's been no prejudice, as in grant, occasioned to the defence, and that's demonstrable, well, then you ignore misconduct, however grave.
Unless, my Lord, you're just simply carrying it forward like in a Bennett-style case where you can't actually change the position that you're always going to be in, so, because that's your status. But Lord, this is certainly, Lord, the approach that appears to be the approach taken by the courts in Canada, where they say, and perhaps I ought to...
That's what I was trying to get. Is there any authority in this country which takes that approach?
But Lord, no. It would be developing the law along the lines of the way that the Supreme Court has taken it. And my Lord, may I just explain, when we were preparing this appeal, we were conscious of the fact that there's an awful lot of fact, and we wanted, if we could, to assist the Supreme Court to develop the law if it felt that was appropriate, and that is why we searched the other jurisdictions.
We're not complaining.
No, but Lord, just seeking to. But my Lord, what's happened in Canada? Because every jurisdiction over the past 20 years, it appears that pretty much every jurisdiction has been plagued by the proliferation of abuse of process applications. So you see it in Australia, you see it in New Zealand, you see it in Canada, you certainly saw it in this jurisdiction following Connolly and Humphreys.
There's a great deal of case law in America on this, which you haven't referred to. But at the end of the day, it probably isn't helpful because there's a division of authority between the United States Supreme Court dealing with federal constitutional law, double jeopardy, and the state courts, which adopt a rather stricter test.
Well, my Lord, we certainly found the position in the United States complicated, Lord, because of the federal position and the state position. And for example, in the Bennett case, there's reference made to some of the United States decisions, some going either way. And since Bennett, it looks as though some of the decisions have gone the other way.
I was thinking of prosecutorial misconduct, where the Supreme Court seems to have said that, and it's all connected with double jeopardy in the United States, where the Supreme Court, the approach of the Supreme Court is that a retrial is not permissible, where it's only not permissible where the prosecutorial misconduct is intended to provoke the defendant in moving for a mistrial. That's the Supreme Court's approach, whereas at least one state adopts the approach of saying a retrial is not possible where the conduct of the prosecutor is intentionally undertaken to prejudice the defendant to the point of the denial of a fair trial, which is closer to the appellant's position.
Yes.
Mr. Perry, you're going to take us to the Canadian case, I'm sure, but the position in our law, or currently, according to Lord Steyn, at any rate, in Latif, was that the law is settled. And as I read what he says in Latif, he's there talking about the abuse of process jurisdiction generally in relation to misconduct cases. And he talks about the balance and so on that we've looked at many times.
Yeah.
Now, are you suggesting that we should apply a different approach, where the balancing process only comes in if the misconduct is carried forward?
Yes.
And it's only at that stage, but at that stage you do carry out a balancing exercise?
Yes. And Lord, may I say that although in Lateef, Lord Steyne said the law was settled. To a degree, it was developing loosely. Because in Lateef, of course, the argument that was being put forward was entrapment, and the remedies that were being discussed were not only stays but exclusion of evidence under Section 78, whereas in loosely there was some consideration given to what the appropriate remedy would be in entrapment cases, and the House of Lords decided the remedy is a stay rather than exclusion of evidence on the basis that the state had brought about the crime and therefore lost its moral legitimacy to continue with the prosecution. That's not the approach that has been adopted, for example, in other jurisdictions, but it certainly was a development on from Lateef. Thank you. Lords, may I just go to the two important decisions of the Supreme Court of Canada. The Tobias decision is Volume 4, Divided 38. This was the case of the Minister of Citizenship, Volume 4, Divided 38, and your Lordships will see from the first page, after the first four paragraphs, the facts are then set out. The Minister was seeking the revocation of the citizenship of 3 citizens on the basis that they'd obtained citizenship by false representations. In fact, they'd failed to disclose involvement in atrocities during the Second World War. And what happened in this case, going over the page, the evidence came to light that an assistant deputy minister, this is about 6 lines down, may have spoken to the Chief Justice with a view to having the Associate Chief Justice removed from the proceedings, and the Associate Chief Justice subsequently removed himself from the case. And the citizens were granted a stay of the proceedings. Well, in effect, what it came down to was the executive considered the Associate Chief Justice to be a troublesome judge, and they wanted him removed, and a stay was granted. And the first instance court granted a stay. The Court of Appeal allowed the minister's appeal, and the Supreme Court rejected the citizen's appeal. And at page 447 of the report, your Lordships will see that it was a judgment by the court, no doubt because of the sensitive nature of the proceedings in question. And the relevant statements of principle appear at page 470 of the report in the court's judgment from paragraph 87 onwards.
Who wrote that?
Well, my Lord, it's simply by the court, and we can see that the court from the first page.
Justice Lemaire and so on. Chief Justice Lemaire and so on.
Chief Justice Lemaire presiding.
Yeah.
And then when the court comes on to deal with the legal principles at page 407, they appear at paragraph 88. And at paragraph 89, most often a stay of proceedings is sought to remedy unfairness to the individual that has resulted from state misconduct. So that would be our category 1 in this jurisdiction. However, there is a residual category of cases in which a stay may be warranted, and that was discussed by Mr. Justice Dubé in O'Connor, which is the integrity principle. And they note after the indented passage, the residual category, it bears noting, is a small one. In the vast majority of cases, the concern will be about the fairness of the trial. We say that and also accurate so far as it comes to this jurisdiction. The residual category tends to be smaller. The usual argument goes to the fairness of the trial. Then paragraph 90, if it appears that the state has conducted a prosecution in a way that renders the proceedings unfair or is otherwise damaging to the integrity of the judicial system, so it's catering for both categories here, category 1 and category 2, 2 criteria must be satisfied before a stay will be appropriate. They are: 1, the prejudice caused by the abuse in question will be manifested, perpetuated or aggravated through the conduct of the trial or by its outcome, and 2, no other remedy is reasonably capable of removing that prejudice. And then 91, the first criterion is critically important. It reflects the fact that a stay of proceedings is a prospective remedy. A stay of proceedings does not redress a wrong that has already been done. It aims to prevent the perpetuation of a wrong that, if left alone, will continue to trouble the parties and the community as a whole in the future. For this reason, the first criterion must be satisfied even in cases involving conduct that falls into the residual category. The mere fact that the state has treated an individual shabbily in the past is not enough to warrant a stay. For a stay of proceedings to be appropriate, cases fall into the residual category. It must appear that the state misconduct is likely to continue in the future, or that the carrying forward of the prosecution will offend society's sense of injustice. Ordinarily, the latter condition will not be met unless the former is as well. Society will not take umbrage at the carrying forward of a prosecution unless it is likely that some form of misconduct will continue. There may be exceptional cases in which the past misconduct is so egregious that the mere fact of going forward in the light of it will be offences, but such cases should be relatively rare.
Do they give any clue as to which ones are so egregious?
My Lord, no. There's no indication, although Regan is a case where the court was split as to whether it was abusive conduct. We'll come on to that. But after
bottom half of paragraph 96, I'm sure Melanchthon will come to it, are examples the court has in mind of such egregious cases, and we rely on those examples.
Thank you very much. I have got that marked, and I'll come on to that. But after considering these 2 requirements, the court may still find it necessary to consider a third factor. Where the affront to fair play and decency is disproportionate to the societal interest in the effective prosecution, then the administration of justice is best served by staying the proceedings, Queen against Conway. We take this statement to mean that there may be instances in which it will be appropriate to balance the interest that would be served by the granting of a stay of proceedings against the interest that society has in having a final decision on the merits. This is not to say, of course, that something akin to an egregious act of misconduct could ever be overtaken by some passing public concern. Rather, it merely recognises that in certain cases where it's unclear whether the abuse is sufficient to warrant a stay, a compelling societal interest in having a full hearing could tip the scales in favour of proceedings. And then on page 473, no likelihood that any abuse will be manifested in the future. Paragraph 94 deals with the damage done to the appearance of judicial independence. Then 95 is that this is the argument, the appellants argued it was a residual category case and it would be to condone the official misconduct and thereby aggravate the abuse. And then at 96, 5 lines down, a stay is not a form of punishment, it is not a kind of retribution against the state, and it is not a general deterrent. If it's appropriate to use punitive language at all, then probably the best way to describe a stay is as a specific deterrent, a remedy aimed at preventing the perpetuation or aggravation of a particular abuse. Admittedly, if the past abuse were serious enough, then public confidence in the administration of justice could be so undermined that the mere act of carrying forward in the light of it would constitute a new and ongoing abuse sufficient to warrant a stay. However, only in an exceedingly serious abuse could ever bring such continuing disrepute upon the administration of justice. It is conceivable, we suppose, that something so traumatic could be done to an individual in the course of a proceedings that to continue the prosecution of him, even in an otherwise unexceptional manner, would be unfair. Similarly, if the authorities were to fabricate and plant evidence at the scene of a crime, the continued pursuit of a criminal prosecution might well be damaging to the integrity of the judicial system. But of course, that's the stay rather than the retrial point. it seems. And then...
Just take that case. Assume that there has been fabrication, planting of evidence, and there has been a conviction. And the question then arises, well, we've now got some other evidence, or whatever it is, let's have a fresh trial. I mean, what view is taken there?
Well, Lord, what is being said there is yes, you can stay those proceedings, but it's not saying that if in the type of case with which we're concerned, you've got untainted evidence that you couldn't then...
Well, isn't it?
Yeah, that sentence beginning admittedly is an example of that. If a past abuse was serious enough, then public confidence could be so undermined the mere act of carrying forward in the light of it would constitute a new and ongoing abuse.
Well, but Lord, what we submit in relation to in relation to this case is that so far as the abusive conduct is concerned in this case, that's been remedied and cured by the quashing of the conviction, and that the approach of the Court of Appeal to say that the future trial would not be tainted by the past abuse was correct.
But that assumes we're not in the residual category.
The residual category?
Yeah. This small residual category where that just simply doesn't work.
Last sentence of 91.
Yeah.
Two. Yeah. Nothing is said here about the seriousness of the offence.
It slightly depends. Do you fit Mullen and Bennett into that last sentence of 91, or are they examples effectively of continuing misconduct because the person's kept here by duress?
Yeah, well,
having been wrongly brought here.
Yes, my Lord, it's the... Yes.
If one treats them as a separate, explicable on the grounds that effectively it's continuing misconduct or continuing abuse to have them here, because they should never have been here, then the only English cases which could fall within the residual category is Grant, is it? Because Latif and Loosely were both cases where inevitably, if you were going to prosecute further, you'd be relying on the transaction in which the police were wrongly misbehaving themselves.
Yes, there's the entrapment category, my Lord, which is Latif and Loosely, and the only other case that falls into the category is Grant.
Yes, where they deliberately said that the misconduct has no future effect whatever, it's all in the past, we can separate it out, be confident there's no prejudice, and nonetheless, we must, so to speak, mark the position by finally staying.
Yes.
It's possible that the disguised extradition or kidnapping cases are in a completely separate category. The fault there could never be cured.
Well, that appears to be a basis for the decisions in those cases, my Lord. And it's also, we would submit, my Lord, important also to bear in mind in relation to Bennett-type cases, that Lord Griffiths was very careful to ensure that he limited the case to those instances where there was an extradition arrangement between the two states that was circumvented. Because otherwise you get into difficulties in the type of Eichmann-type case or the Okerlund-type case, which I know your lordships have looked at in the context of jurisdiction of the Human Rights Act. Okerlund was the
Nairobi.
The Nairobi case, where Bennett was deployed before the Grand Chamber in favour of the applicant to say that he was entitled to a remedy on Bennett grounds. And the court's assessment was, well, there was no extradition arrangement between Kenya and Turkey. Thank you, my Lord. And Turkey. And therefore it wasn't a Bennett-type case, and the same sort of reasoning can be seen.
So it was okay, was it, to ship him out forcibly or
by trick?
Surreptitiously?
Yes,
I see.
So that was all right, my lord, and also the Strasbourg court was very keen to say that there's nothing wrong with state-to-state cooperation. The difficulty about the extradition cases is there is in place a treaty where the states have agreed at the level of international law that extradition will take place with certain safeguards available, including the specialty rule, so that if you're extradited, you may only be prosecuted for the offence.
That's right. Was Mullen, so what
Mullen was also...
circumventing extradition.
Yes, that's also the case. The case.
That's where the accused is deprived of the protection he would otherwise have had under the extradition treaty. It's not a case, as I suggested yesterday, of breach of international law, because in each of these cases there was consent of the sending state.
Well, that's certainly also, my lord, seen in Ocalan, where they say that Kenya and Turkey had resolved their differences and they'd agreed it. But my lord, the way you could take this on would be, suppose Mr. Bennett, who in fact wasn't improperly returned from South Africa, as the Scottish courts later ruled, but nevertheless assumed for these purposes that the assumed facts before the House of Lords are correct. Suppose you return him to South Africa, then seek his extradition, and then extradite him. You would have cured the taint, and you could prosecute, and there'd be nothing. Now, no one could say in those circumstances, well, now you've got him here, and you've got him here lawfully, because you behaved so badly in the past, you now shouldn't prosecute at all. We would submit that that's now relegated into history. It becomes an historical irrelevance. And therefore, what you do is you look prospectively to see whether you can have a trial which does not carry forward any of the taint. And in relation to the test, my lord, at 474, a reasonable, fully informed member of the public.
Which paragraph?
I'm sorry, my lord. Paragraph 97 at the top of 474. A reasonably, fully informed member of the public confronted with a continuation of the proceedings would not think that an injustice. So that they were applying a reasonable member of the public test, and they found that
on the facts of that case.
Yes. And Lord, your lordship mentioned about the seriousness of the offence. I think that can be picked up by the Regan decision, which effectively follows Tobias. It's volume 5, divider 45. It was, as your lordships know, criminal proceedings against the former Premier of Nova Scotia, charged with sexual offences, and the abusive conduct involved judge shopping, pre-charge interviews, improper police announcement of the charge, and the page 306. Your lordships can see who was in the... Sorry, 305. I'm sorry, my lord. 305 for the majority. Lords, may I say that the dispute between the court was not in relation to the legal principles to be involved, but on the application of the principles in this particular case. So the majority didn't think that the conduct was abusive, and...
Well, they were just following the principles established in Tobias.
Yes, and the minority, Mr. Justice Binney giving the judgment, thought there was no basis for overturning the lower court's decision. And,
I mean, he'd been counselled successful in the first case.
Yes. And then page 306,
the first paragraph on the page is there's the issue, and then the statements of principle, my lords, appear at 325 to 327. And it's really a discussion of the principles. And at 327, under the heading Stay of Proceedings, they say it's a drastic remedy, the ultimate remedy, and they refer to Tobias, and they repeat Tobias, and they effectively deal with it in accordance with the principles. And at page 354 is the summary of the majority's opinion. No abuse of process, not so egregious, vexatious, oppressive, or which would offend the community's sense of decency and fair play. And the societal interest is discussed at from page 358, but the important passage is at page 361. And it's the paragraph in the middle of that page, my lords, where the majority say there are many societal interests engaged in this case which the trial judge failed to factor into the balance. Victims of sexual assault must be encouraged to trust the system and bring allegations to light. As the police saw it, there's evidence of a pattern of an assailant sexually attacking young girls and women who were in a subordinate power relationship with the accused, in some cases bordering on a relationship of trust. When viewed in this light, the charges are very serious, and society has a strong interest in having the matter adjudicated in order to convey the message that if such assaults are committed, they will not be tolerated, and that young women must be protected from abuse. So that there's a discussion in relation to the societal interest.
How do we get paragraph numbers here? I mean, I see that you quote this paragraph as 116 in your printed page.
I'm very sorry, my lord. It appears as though in the printing of this, some of the paragraphs have been cut off, my lord.
Say that again. I mean, I'm sorry if I see. We have got one or two. But
You have to work it.
So I've used... And
yeah, I see.
And, my lord, just to see
So just so that I understand this passage at 116, where he's talking about the seriousness of the offence, that comes in at the stage, going back to Tobias, of he says, well, asking the question whether carrying forward of the prosecution will offend society's sense of justice. It isn't a residual, egregious case, but it has got past the hurdle or over the hurdle of being carried forward.
Yes,
that's correct.
That's right, Lord. That's the way that the analysis seems to proceed. Because one of the things that's being emphasised here, as it is in all cases, is the dramatic nature of the remedy and the fact that something very important happens when you say society cannot have a determination of the allegation brought against this individual. And so far as the minority is concerned, my Lord, the fact that they apply to bias is made clear at 398, where they set out the test. It's not necessary to deal with it. But the point that my Lord Sir John Dyson just made is also made clear at page 401 of the report. I'm very sorry that some of the page numbers don't appear, but it's page 400, the page number is there. And on the next page, your Lordships will see in the bottom half of the page, finally at the third stage of the Tobias test, the court is to consider if it still has any uncertainty, the balance between any harm to the justice system that would result from taking the charges to trial. So those are the two leading cases from Canada.
This one, I always find this terrible. The harm to the justice system. I mean, what does that mean, actually?
Well, Lord, so far as there is some discussion of how you gauge it in one of the cases from the Canadian Supreme Court on excluding evidence under the Charter, which talks about bringing the criminal justice system into disrepute.
That kind of thing, it is.
Yes. And, but Lord, we say that there doesn't have to be any elaborate test of community values or what the man in the street thinks, my Lord, because the Court of Appeal personifies the reasonable man for these circumstances. And although, as I think one academic expressed it, that although judges may disagree as to what's reasonable, a court could never disagree with what's reasonable because the court personifies what's reasonable. And therefore, when the court is saying that it will act in a particular way, it's for the court's assessment. And Lord, that's also clear from the structure of the 1968 Act itself, because while I just deal with that point, Lord, if your Lordships take up the extract that we have in Volume 6, Divider 56 of the Criminal Appeal Act, we haven't got, for understandable reasons, we haven't got the whole of the Act. But, Lord, may I just make this point, because it's the importance that Parliament attaches to the views of the Court of Appeal. That's the theme that runs through the whole of the Criminal Appeal Act. Your Lordships can see that from Section 2, subsection 1, which is the ground for an allowing an appeal. Subject to the provisions of this Act, the Court of Appeal shall allow an appeal against conviction if they think that the conviction is unsafe. And then if your Lordships look at Section 3, subsection 1, which is the power to substitute conviction of alternative offences. This is where you're convicted of one offence, but there's a lesser included alternative, or your conviction is quashed. And your Lordships will see it appears to the Court of Appeal that the jury must have been satisfied of facts which proved him guilty of the offence. So the primary decision maker, again, the Court of Appeal, and that's also clear from Section 7. And the Lords, we don't accept that the Crown carry a burden of persuasion in relation to Section 7. That's not what Section 7 is driving at. Section 7 is driving at an evaluation conducted by the Court of Appeal. That's made clear by subsection 1, where the Court of Appeal allows an appeal against conviction, and it appears to the Court that the interests of justice so require, they may order the appellant to be retried. So even if the Court of Appeal, even if the prosecution were to say, we don't think, we're not actually applying for a retrial, the Court of Appeal could say, well, we think there should be, and we're going to order one. So to say there's a burden on the prosecution, we would submit is erroneous. And the only burden of proof that there is in this area, which is well established on the authorities, is, as the appellant concedes, a burden to establish on the balance of probabilities that a stay is an appropriate remedy. So ordinarily it would be for the defendant to establish that. But Lords, may I I've dealt with many of our points, but may I just make some short points about the decision of the Court of Appeal, having referred to Section 7 of the Act and the way the Court of Appeal approached it, because the following matters appear to us to be significant. First of all, as already been noted, the essential basis of the Court of Appeal's decision to order a retrial was that there was in the court's opinion new and compelling evidence against the appellant and that a retrial was in the interests of justice. And by applying the new and compelling evidence test, the Court of Appeal adopted a test in the appellant's favour so far as the threshold for ordering a retrial is concerned. The second point to note about the Court of Appeal's approach is that we would submit that it's consistent with the case law not only in this jurisdiction about not a disciplinary jurisdiction and a remedy of last resort, and also taking into account the seriousness of the offence, but also with the approach of the case law in other jurisdictions. And I've already referred your lordships to the cases in Canada. And your lordships also, without, if I may, I won't turn it up, but your lordships may also be assisted by the decision of the High Court of Australia in Jago, which is volume 4, divider 40, and there are some helpful observations in the judgment of Chief Justice Mason, page 30 for the basis of the jurisdiction, page 31.
So can we just?
I'm sorry.
I think we might just look at them if you don't mind, Mr. Chairman.
I'll deal with it by going to the decision, Lord. Lord, Jago was a delay case, Lord, but it influenced the law in this jurisdiction because when there were many applications for stays on the grounds of abuse of process, usually on the basis of delay, in the 1980s when the jurisdiction started to develop, this case and some of the dicta in it were adopted by Lord Lane, Chief Justice, in the Attorney General's reference case, which is the Attorney General's reference number 1 of 1990, which is in the bundles, the first bundle of authority at divider 3, but I needn't turn that up, but Lord Lane referred to this decision approvingly, but your lordships will see at page 30 in the judgment of the Chief Justice, just before the middle of the page, the paragraph, fairness to the accused is not the sole criterion when a court decides whether criminal trial should proceed. And then he adopts the approach of Mr. Justice Richardson, which was in the New Zealand case, which is referred to on the previous page, the Department of Labour case. And it's at the end of that quote, it's whether the continuation of the prosecution is inconsistent with the recognised.
Sorry, where are you reading now?
The end of the quote, my Lord, on page 30.
On the top of page 30?
At the bottom of page 30, my Lord. At the bottom of that.
Yes.
It's whether the continuation of the prosecution is inconsistent with the recognised purposes of the administration of criminal justice and so constitutes an abusive process. The important point, my Lord, is the prospective nature. On page 31, exceptional circumstances. And
sorry, where is this? The exception?
on page 31, my Lord, about 12 lines down. In each case, the power will be used only in most exceptional circumstances to order that a criminal prosecution be stayed. And it's also dealing with the orders that may be made in the course of a trial to ensure fairness. And then the balancing exercise is page 33, in the middle of the page, the paragraph that begins, the test of fairness which must be applied involves a balancing process, for the interests of the accused cannot be considered in isolation. And page 34.
I'm not actually following this because
I'm
he
sorry.
said it's not the sole criterion, fairness to the accused. Is that right?
Yes.
That's what you just read. So what's this about touchstone in every case is fairness? How does that work?
At 33,
Yes,
Lord,
I mean,
the
I'm
test
sorry, I
of
just don't know
fairness involves a balancing.
Yes, sorry, what I'm not quite following is why on page 30 he says that certainly in this sense fairness to the accused is not the sole criterion. It's just I'm trying to marry up those two statements. I mean, I just don't know the case, so I don't know.
I'm sorry, my lord. It was a delay case,
Yes.
Lord, where
Yes.
it was effectively a white collar investigation which had taken many, many years. The prosecution had been very dilatory in bringing the proceedings, and the point that was being made by the High Court is that you don't look single-mindedly at the interests of the defendant. You look at other interests, particularly the interests that are in play when you come on to consider the interests that are involved in criminal proceedings. And that may be also clear when we come on to look at something that's said by Mr. Justice Brennan. But on page 34, the first main paragraph on page 34, to justify a permanent stay, there must be a fundamental defect which goes to the root of the trial of such a nature that nothing a trial judge can do in the conduct of the trial can relieve against its unfair consequences. That was from Mr. Justice Wilson in an earlier case of Barton. And where it's the delay case, must show that the lapse of time is such that any trial is necessarily unfair, so that any conviction would bring the administration of justice into disrepute. And then, so far as Mr. Justice Brennan was concerned, he deals with the different interests in play in criminal proceedings. At the bottom of page 49, going on to page 50, and this is the bit, Lord, where Mr. Justice Brennan, about a third of the way down the page on page 50, says refusal by a court to try a criminal case does not undo the anxiety and disability which the pendency of criminal charges produces, but it leaves the accused with an irremovable cloud of suspicion, and it's likely to engender a festering sense of injustice on the part of the community and the victim. The reasons for granting stay orders which are as good as certificates of immunity, would be difficult of explanation, for they would be largely discretionary. If permanent stay orders were to become commonplace, it would not be long before courts would forfeit public confidence. That was effectively what Lord Lane relied on in the Attorney General's reference case. And then just two other references, Lord. In Mr. Justice Tui's judgment, it's made clear at page 72 of the report, just in the middle of the page after the reference to Carver and the Attorney General on page 72, the court is alert to see that a person charged receives a fair trial, not to punish the behaviour of the Crown. So,
I mean, this is all in the context of delay, where very generally you can compensate if there is actual, to avoid any actual prejudice. I mean, this isn't prosecutorial misconduct.
I fully accept that, my lord, and the only point, my lord, is that whether you're in Category 1 or Category 2, the same interests, or it's been made clear, exceptional remedy and not deterrent rationale. But Lords, those are the only reasons for dealing with that. And then, but Lords, the confession evidence in the case, we've summarised at paragraphs 59 to 72 of our written case. and it's dealt with in detail by the Criminal Cases Review Commission in their report. See Volume 2 of the Core Bundles, Divider 6.
I want to ask you about it. I mean, I think we're reasonably familiar, but most of it involves disclosing that he's in prison and the background to why he's in prison, and no doubt that would be explored by the defence as well as an explanation, playing the probation or the parole system, and so on. So, doesn't that make this rather a curious trial? Normally, the fact that he was in prison and the background, presumably the first trial, would have to come out as well. None of that would play a part in a trial for murder.
Well, my lord, if that's going to be the position, my lord, I mean, one of the things that comes out of the confessions, and we don't know what the current position is that when the appellant was confessing, he was saying, I want a retrial, and I would be willing to plead guilty to manslaughter. Of course, the prosecution have said that that's not acceptable. It will then be for the defence to say, well, are these confessions untrue, or is it really the case that you're saying this was a case of manslaughter rather than murder? But my lord, it's difficult to predict at this stage precisely what the shape of the case will be. For example, in relation to the unknown unknowns argument this morning, it's very often the case in criminal cases that defendants say that there's evidence that could have been available and it isn't available. But the answer to that is that's what the trial process is designed to adjudicate upon, and you can make those points. It's very often the case that defendants say the police missed a fingerprint. If they'd found it, well, they can make that point. It doesn't mean a trial's unfair, and there's no reason for suggesting that this trial will be unfair. If the defendant wants to challenge these confessions, he will have all the usual protections. If, on the other hand, he wants to explain them away or says that they're true and he's really guilty of manslaughter, then that can be evaluated by the court.
But I mean, inevitably, any discussion of these confessions will be on the basis that he was at the time serving a life sentence for murder.
Or, yes, inevitably, it looks as though that would have to be the case.
That's rather an unusual background against which to have to discuss and debate whether these are, genuine and what was the purpose, all the rest of it, isn't it? I mean,
well, my lord,
won't the jury be quite interested to know why he was in prison serving life sentence for murder, and how does all that explain to them?
Well, my lord, that is something, depending upon the issues in the case, can be explained. I mean, very often you have crimes committed in prison.
No, of course.
And crimes committed by people who are serving life sentence, who say, I committed this because I was serving a life sentence. If it's a fact, the jury should not be deprived of that information, and everything that should be done to ensure that there is a proper adjudication on the facts should be done. They shouldn't be kept in a state.
So they'll be told that he was serving life in prison, but as a result of corrupt, perjured evidence.
Well, it depends, my lord. It depends. In any case where there's a retrial, suppose someone confesses while they're in prison, which is to a fellow prisoner, which is sometimes the case. The Stone case was an example where an explanation has to be given. Well, what were you doing in prison? Well, I was convicted, and eventually my conviction was quashed. Now, the parties may say, we don't need to go into all the background as to why the conviction was quashed, but some formula can be agreed. But, my lord, it's not an impediment to the case going ahead. But
the judge has to direct them, of course, They have to consider it simply on the evidence and so on,
Yeah,
not
yes.
speculate and all these usual kinds of things.
Yes, my lord. Lord, would that be a convenient
Yes, Mr.
moment?
Berry, are we making reasonable progress?
Yeah, my lord, what I'm going to move on to is just deal with some points from the oral submissions, and I think I can deal with those, I hope, quite crisply.
Thank you very much. 2 o'clock.